We are here to launch the Citizenship and Nationality Digest, a collaboration between Namati and Kenya Law. Namati is an organization that advances social and environmental justice by building a movement of people who know and shape the law. Kenya Law is a semi-autonomous state organization that provides legal information online and also in hard copy. Most of it is for free, and you can visit our website on www.kenyalaw.org. So all protocols observed, I think it's time to begin. We're going to start with an opening prayer from Emily Nakungu. Emily shall provide us with an opening prayer. I can't see Emily, so as we wait for Emily, here we go.
All protocols observed. Ladies and gentlemen, good morning. Let's bow for a word of prayer. Bwana Mungu wa majeshi, muumba wa mbingu na nchi, twaja mbele zako na shukrani kwa wema wako. Tunakushukuru kwa kutujalia kufika hapa salama salmin. Tunapozindua kitabu hiki, twaomba uwe nasi katika hafla hii. Kwa kuwezesha ushirikiano huu kati ya Kenya Law na Namati, tunasema ni asante. Tunaomba ya kuwa kitabu hiki kiweze kuwafaa watakao kitumia. Tutakapomaliza hafla hii, sifa na shukrani zitakurudia. Wageni wetu, tunaomba wawe salama. Tunakushukuru kwa sababu mwafikisha hapa kusherehekea pamoja nasi. Ni katika hayo machache tumeomba, tukimpa Mungu wetu sifa na shukrani. Kwa Kristo Bwana wetu tumeomba na kuamini. Asante.
If you might wait to home, just so ladies and gentlemen, right now it's time to rise up for the national anthem. It will be done in we'll first have the Kenya national anthem, followed by the East African community anthem. Home.
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuwajibike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu. Uzalendo pia mshikamano, iwe msingi wa umoja wetu. sote tuilinde, tuwajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu. Viwandani na hata mashambani, tufanye kazi sote kwa makini, tujitoe kwa hali na mali, tuijenge jumuiya bora. Jumuiya yetu sote tuilinde, tuwajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you. You may have your seats. So before we begin with the event, on each table, there's a small document, there's a small QR code in the middle of each table. Should you want the event program, kindly just scan the QR code, and if you scan the QR code, you'll have the event program. Another small announcement is that we still have the invisible enemy of COVID-19 amongst us. So kindly try and observe COVID protocols. If you're touching a new surface, kindly try and sanitize. There's a sanitizer on each table. And if you're not eating or on the platform talking on the microphone, kindly try and wear your face mask. Now, without further ado, I think it is time to begin the event. So first up, we'll have our opening remarks from Namati. To guide us in this discussion, we'll have Laura Goodwin, who shall make the opening remarks from Namati. Laura Goodwin, I believe, is the Citizenship Director for Namati. So Laura, have the floor.
Good morning. Welcome to all of you, our esteemed guests, the editor, CEO, and the staff of our co-host, Kenya Law, government representatives, representatives of academia, development partners, civil society, our paralegal partners, the press, and all of you. We're so glad to see everyone here this morning. Citizenship is often referred to as the right to have rights, the right that underpins being able to exercise political choice, to access services, and to truly belong in society. The Constitution of Kenya 2010 is a progressive instrument that establishes who's a citizen of Kenya and the rights and responsibilities that accompany citizenship. The Constitution reformed many aspects of citizenship law in the country, including ensuring that both men and women can confer citizenship to their children on an equal basis, and providing new options for stateless persons to obtain nationality in Kenya. But citizenship is often still contested in practice. Access to citizenship, whether by birth or by registration, is something that so many people here and around the world take for granted. Yet inability to gain recognition as a citizen, or inability to access identification to prove that citizenship, creates massive inequalities and imbalances at the most fundamental level, challenging inclusion, fairness, and stability. Namati as an organization focuses on legal empowerment, knowing the law, using the law to seek justice, and then shaping the law to improve the legal framework and the system itself. Legal empowerment is a powerful tool for improving people's ability to access nationality, acquire legal identity documentation, and benefit from the multitude of rights that come with citizenship. In our own work, Namati and partners support community paralegals from groups who have citizenship rights in law but face discrimination when trying to acquire proof of nationality in practice. These paralegals walk hand in hand with their fellow community members who otherwise might fear to use the law because of their own history of negative experiences with the system. For them, knowledge of law is not only a new tool, but alongside support from a paralegal, the law gives people hope to persist, to make sure that their citizenship is secure, and to make sure that they have the identification to prove it. The potential of these community-based initiatives does not stop with the provision of individual assistance or local organizing. And in fact, when there are structural barriers that prevent access to citizenship or documentation, that individual assistance alone might not be enough. Experience and evidence from legal empowerment initiatives at the grassroots level can be the basis for powerful community-led change, for people to shape the very laws that affect their nationality, their access to documentation, and their lives. That push for change is represented in many of the cases contained in the digest being launched today. Through judicial and administrative review, the law on citizenship continues to evolve both in theory and in practice. These cases help ensure that constitutional protections are realized, and they expand interpretation of what it means to implement the law in practice, including in a comparative perspective across Kenya and other jurisdictions. And this digest is also important because for legal empowerment to happen, the law must be accessible to all. In addition, in this very moment, with the Huduma Bill proposing the largest scale overhaul of Kenya's laws on citizenship and identification since independence, understanding the current laws, jurisprudence, and practice around citizenship is more important than ever. So I'm looking forward to an interactive discussion this morning on citizenship and nationality, and I really thank you all for being here to engage on this critical topic. We extend our deep gratitude to the team at Kenya Law for the partnership in creating this case digest to make citizenship law and jurisprudence more accessible to everyone. We look forward to further collaboration to put the law in people's hands and in turn ensuring that all can access their rights to nationality, fair administrative action, and all of the entitlements and opportunities of citizenship. Thank you.
Makofi Zalora. And a hand for Namati as well, the host for the evening. They're the ones who provided us with this sumptuous breakfast, and they're hosting us here at Saruva. So Makofi and Namati here. Now, on the other side, we have our partner from the public side. The Kenya Law CEO and editor shall be making his opening remarks. Professor Jack Mwimali, karibu.
Thank you very much. Honorable council members, Kenya Law who are present, members of the board and management of the management team of Namati, government representatives, representatives of various government institutions, development partners, civil society organizations, media fraternity, colleagues, distinguished guests, ladies and gentlemen, greetings from Kenya Law. I'm pleased to welcome you to the launch of the Citizenship and Nationality Rights Case Digest. This is the first publication in a series of specialized publications in that particular area. This publication is a concerted effort between Namati and National Council for Law Reporting, which is Kenya Law, and consists of national and international jurisprudence that covers various issues on nationality and citizenship. The case digest reflects the impact of Constitution of Kenya 2010 on nationality and citizenship. Whereas the repealed constitution restricted the scope of application of rights related to citizenship and nationality, the 2010 Constitution has widened that scope. The basis of this digest is to fundamentally reflect on the progress that Kenya has made on laws and the emerging jurisprudence on nationality and citizenship, particularly post the 2010 Constitution. The scope of the digest covers citizenship by birth and registration, dual citizenship, identification documents, stateless persons, and fair administrative action. The digest offers the groundwork on citizenship and nationality. It is an informative tool that not only contains knowledge, but also offers a glimpse into the different perspectives of local, regional, and international courts on citizenship. It is a reflection of the Kenya's transformational and social environment that was that was initially most unfavorable to minority communities. It discriminated against gender. Acquisition of citizenship was a challenge, and whether it was by birth or registration, there was a lengthy process that resulted into the denial of basic rights. In addition, the reprieve offered in administrative review or judicial review at that point was non-existent. The right to a fair administrative action has emerged as a cross-cutting theme that has featured throughout the digest. The judicial system has come up strongly in condemning arbitrariness by various actors in the course of seeking the right to nationality and citizenship. There are case law that acknowledge the previous restricted approach of legal protection and legislation over citizenship and nationality. An example is the fact that the repealed constitution never provided for dual citizenship. The case of Gama Duba Gufu versus Attorney General and another is a classic example of the court standing against the government when it was arbitrary in stripping the right to nationality. This case reflects the application of the Constitution and cross-cutting themes of fair administrative action. It is also an example of the risk that is faced by cross-border communities. Transborder communities and minorities have lived in Kenya for hundreds of years, faced with insecurity of statelessness. It is reported by the United Nations High Commissioner for Human Rights that by the year 2020, the estimated number of stateless persons was in the increase, and that group of stateless persons included, but are not only limited to, in Kenya, the Pemba, the Galjean, the Shona, the Indians. The Kenya Somalis and the Nubians are rendered stateless because they have limited access to Kenyan identification documents. It is noteworthy that the Nubian community has vocally relied on the legal system to seek justice against discriminative legislation, whose effect would fundamentally restrict the access to identity documents. At the international level, the African Court has also continually determined the process regarding nationality and citizenship, especially with respect to documentation and discrimination against these groups, including the Nubians. Ladies and gentlemen, the digest is an affirmation of the history of progress into the future, a future of knowledge and a future with the ability to claim one's right to citizenship. Jurisprudence influences delivery of justice, and developing of legislation is a constant changing aspect of the society. The digest is in tandem with Kenya Law's implementation of its strategic plan of 2018 to 2022, which places emphasis on the importance of publication of specialized digests that highlight the emerging jurisprudence and the law in various themes specific to intended stakeholders. It is therefore a great milestone and an honor to have the Kenya Law Fraternity being part of this publication. the first digest that highlights the theme of nationality and citizenship. As we endeavor to disseminate the specialized digest through Kenya Law's website and physically, and in ensuring that all public legal information is universally accessible, we trust that it will find meaning, inform and transform the relevant policy, practices, and legislative processes that impact on the pertinent thematic areas. I recognize our council led by the Honorable Chief Justice, who is represented today by Professor Winnie Kamau, for the presence and support in the process. My colleagues who participated in the sourcing and compilation of the relevant case law are also recognized. Special mention goes to Njeri Gidanga, Mrs. Beryl Ikimari, Mr. John Ribia, and Mr. Robert Basweti, under the stewardship of our Deputy CEO, Mrs. Janet Munyoki. Together, the partnership mobilization team comprising Mr. Pascal Otieno and Ms. Edna Mudaura, and the wider planning team led by Ms. Emily Nahungu and Ms. Wahome, have done an immaculate job in execution of this project. The Namati management team, under the stewardship of Mrs. Laura Goodwin, Mr. Mustafa Muhammad, Mr. Yusuf, Ms. Aisha Hagai, and Mr. Kelvin, thank you very much for guiding the development of this case digest and for the great partnership that we have enjoyed. We actually look forward to exploring other emerging issues and areas in future. Last but not least, I sincerely thank all the stakeholders for taking time to be with us today to witness this occasion. We are open to partnership in areas of mutual interest and look forward to furthering our engagement beyond the launch today. Welcome, karibu sana, and thank you.
Makofi ya Professor. We live in a very integrated world today. You can access almost everything from the handheld device you have on your mobile phone. But the irony is, when it comes to services from the government, without a small thing called an ID card or a passport, national identity documents, you are literally shut out of everything. You can't open a bank account. You can't go and study in the university. You're shut out from the entire society because of the lack of an identity document. And it's been a real challenge, especially in Kenya, where we have the highest number of refugees in the world. And we have a lot of people who have been put in this conundrum where they are put as stateless persons because they're not recognized by either of their governments, because we live in the Great Lakes region. All our neighbors, from 1945 to 2022, we live in the region that has had the most armed conflicts in the world. And we find that a lot of these people come to find a place to call home, and they end up coming to Kenya to look for refuge. And we have a lot of people who have been denied services because of a lack of a national identity card or any national identified document. And there are many other challenges that are brought up because of a lack of national identification documents. And to get us more on this, we'll have a moderated discussion on citizenship and nationality rights. It shall be conducted by Namati and Namati's community partners. So to get on this, we'll have the Senior Program Manager for Citizenship in Namati, Mr. Mustafa Mahmoud. He will guide us in the moderated panel. So karibu, the panel is yours.
Good morning. Protocols observed. Good morning once again. As the MC has ably mentioned, my name is Mustafa Mahmoud. I've worked in this field for the past 9 or so years. And apart from working in this field, I've been, I wanted to say the beneficiary of discrimination, for lack of a better word. But at the same time, I can say, because we are trying to get out of the victim mentality, now we want to see in another angle of saying, I have lived through this. I have lived experience in this. I'm an expert of this because I've lived through it. But today it's not about me. Today I want to shed light through people who have lived this situation and people who are living with these people who are going through this. Allow me to introduce my first panelist. My first panelist is Amos Mwatata. Amos Mwatata works with Haki Center at the Coast. Haki Center is one of our partners that work with communities that are completely stateless and communities that are at risk of statelessness. And I'll explain the difference between the two later on. Amos, karibu. Allow me to introduce my next panelist. My next panelist is Mohammed Abdullahi. Mohammed Abdullahi is a Nubian, but also he shares another kinship in Tanzania. His father is a Nubian, but the mother is a Tanzanian. We'll hear more about his life and how it has affected him. Mohammed, tafadhali, karibu. Allow me to shed more light a little bit because one of the case digests that we have in the book, it's talking about the fact that citizenship, it's number 3. Citizenship by birth could not be taken away by refusal to provide documents of identification. Why am I citing this? It's because most of the times these communities that we've worked with have had challenges for years getting documentation. Are they stateless? And what is statelessness? You know, most of the times we throw jargons around left, right, and center, and we forget that there is that regular mwananchi, and that is the spirit of this case digest. When you talk about statelessness, we are talking about people who do not have protection by any country of nationality. So basically, you live in Kenya and think you're a Kenyan, but Kenya says, my friend, you're just a visitor here. Wewe umetoka Mozambique. And then when you go to the consulate of Mozambique, wanakuambia ya kwamba, for you, your nationality expired 100 years ago when your community moved out of this country. So basically, Kenya assumes you are here by the virtue that you are a citizen of Mozambique. And Mozambique assumes that you're a Kenyan. But in the real sense, none of those two countries recognize you. Then there's this risk of statelessness. The risk of statelessness comes in a way that, and when we talk about statelessness, we have to say that because you're not documented does not mean you're stateless, but it can lead to you being stateless. How? By the fact that you've been denied an ID card, a birth certificate for years and years. You will think you're a Kenyan, but Kenya says, my friend, wewe nationality yako is in doubt. And that doubt can escalate to the extent that your children will never get birth certificate. So that child has a higher risk of being stateless. But anyway, these are discussions that we can further on. I wanted to begin with Abdullahi. Abdullahi, nataka utuambie historia yako. Umewasha mic. Abdullahi ni nani? Anaishi wapi? Ni mzaliwa wa wapi?
Habari zenu. Majina naitwa Mohamed Abdullahi. Ni mzaliwa wa Kibra. Naishi Kangemi. Nilianza kutafuta ID nilikuwa 2014. Mpaka saizi sijaipata.
Labda utuambie wazazi wako ni kina nani, wanatoka wapi? Si lazima utuambie majina, lakini tuambie labda ni Mnubi au nini kama hivyo.
Ja. Babangu ni Mnubi, mamangu ni Mtanzania. Yeah.
Na imekuathiri kivipi?
Imeniathiri juu after mamangu na babangu kuachana, ilibidi nikaishi na mama. After kuishi na mama, ikabidi after kuwa mkubwa nikatafuta babangu. Nikakuja
Na hiyo kuishi na mama uliishi naye wapi na ulirudi mwaka gani? Na katika ile kuishi naye, je, ulikuwa Kenya au Tanzania?
Niliishi na mama Tanzania kwa miaka 7, nikakuja Kenya.
Kama uko na miaka ngapi vile ulirudi Kenya?
When nilirudi Kenya niko na miaka 20.
Okay. Na vile ulirudi Kenya, ukapata babako. Je, uko Tanzania ulikuwa na kitambulisho au ulikuwa naishi vipi Tanzania?
Tanzania sikuwa na kitambulisho. When nilirudi Kenya, kapata na babangu. Ndio akaanza kunisaidia venye nitapata ID card, lakini sikufanikiwa mpaka sasa hizi.
Na kwa nini unaona ya kwamba unataka kitambulisho ya Kenya na si ya Tanzania?
Nataka kitambulisho ya Kenya juu nimezaliwa Kenya. So mimi ni Mkenya. Na nahitaji kitambulisho ndio niweze kupata kazi.
Na saizi uko na miaka mingapi labda?
Sasa niko na 29.
Katika hizo miaka 9 ambao umetafuta kitambulisho, imekuathiri kivipi labda?
Ya, imeniathiri kama vile nimesema, kazi sipati. Hapo mwanzoni nilikuwa nafanya kazi, lakini nikafikia mahali wakaniitisha ID card. Lakini sasa mimi sasa ni kushughulika kupata hiyo ID ndio inakuwa shida.
Na pia umesema ya kwamba umekuwa ukiapply kitambulisho miaka kadhaa. Na ile kwa katika application yako, kwa nini application yako haijafaulu labda?
Wanasema ni process, wanasema maybe fingerprint za babangu hazionekani. Guys,
Fingerprints ya babako kwa nini labda? Kwa sababu labda watu wanashangaa fingerprint ya baba inatakikana kwa apply kitambulisho.
Okay. Fingerprint ya babangu haipatikani kwa sababu anafanya kazi ya jua kali. Unaona? Sasa kupata hiyo vidole yake na kuwa na shida.
Na vidole vyako vimechukuliwa?
Vile
ulienda kwa apply kitambulisho, unaweza kutuambia ulienda na documents gani na process ambayo ulipitia labda?
Okay. Nilienda na living certificate na card ya clinic na ID ya babangu. Mamangu hakukuwa na ID.
Na hiyo fingerprint ya baba inatakikana kwa nini?
Fingerprint ya baba anatakana juu anasema eti kwamba system haifanyi. Haionekani yani. Yeah.
Sawa. So basically, why did we choose this example? We go back to the supreme law of the land, the Constitution of Kenya 2010, Article 14. Who's a citizen by birth? And I don't want it to be like I am putting my own words into the Constitution, but allow me to read word by word. A person is a citizen by birth if on the day of the person's birth, whether or not the person is born in Kenya, either the mother or the father of the person is a citizen. Now let's take an example of Mohammed, isn't it? Muhammad's father is a Kenyan. His mother is a Tanzanian. And by the virtue of him having a Tanzanian mother and a Nubian father, gives him more doubt. Because first, his father is a Nubian. Secondly, his mother is a Tanzanian. When we talk about the fingerprint of the father, it's because for Nubian applicants, after applying for an ID, your father or a mother has to come and stamp their fingerprint on your application form, which is not a requirement for any other Kenyan, not unless you live in Northeastern. So basically, by the fact that there's a discriminatory procedure that someone has to go through, and then now another context comes into place, the nature of work. Babako anafanya kazi gani haswa?
Babangu anafanya kazi ya plumber.
Yes. Now, look at the volatile work that he's doing. It means the fingerprints erode. And the fact that the fingerprints have eroded, it means the son cannot get an ID until the day that the father will have fingerprints. So let us ask ourselves, is this fair administrative procedure? And those are the things we are trying to look at. What is the disparity between law and practice? Now let me go to Amos. Amos, katika kazi zako una changamoto gani ambao mnapitia katika jamii ambao zinaishi at the coastal areas?
Asante, hamjambo. Naitwa Amos Mwatata, nafanya kazi na Haki Center tukiwa kule Pwani. Jambo moja ambayo ama kitu kimoja ambacho kinatusumbua ama imetupa tumbo joto ni kuwa tunapofanya kazi na wenzetu kama kina Mohamed kule Pwani, ni shida. Kwanza kuna zile jamii ambazo zimekuwa profiled. So ukienda kutafuta kitambulisho, provider unajulikana babako ama mamako ni Mpemba, then wewe unaambiwa hebu kaa nje kwanza. Hiyo ni kitu ya kwanza. Kitu ya pili, kitu ambayo ni cha muhimu kabisa, birth certificate. Kupatikana pia inakuwa shida. Ukiwa ni mzazi, either babako ama mamako wako katika zile jamii ambazo kupata hizi documentation inakuwa shida, kama jamii za Kipemba, Makonde na zinginezo, kwanza kupewa birth notification inakuwa ni shida mpaka ulete vitambulisho zote mbili. Kitu cha pili, unaweza nyimwa ama upewe, na ukipewa kupata hii birth certificate pia inakuwa kazi nyingine, kwa sababu kutoka pale ameandikishwa birth notification mpaka pale anaenda kuchukua certificate of birth inakuwa ni shughuli nyingine kwa sababu ya distance. Mtu anatoka all the way from Vanga, which is the other end ya Kenya border na Tanzania, anaenda kuchukua birth certificate Matuga ambayo ni Kwale, na hiyo distance inakugharimu zaidi ya 1,000 tikiti, na unaenda kutafuta kitu ya 150 ama 50. So na hizi jamii ni zile ambazo zinaishi katika hali ya uchochole. So kufikia hapo mtu hana ile hamu ama hana hata haja ya kutafuta birth certificate kwa sababu ya vitu kama hizo.
Naam, katika hile labda tupatie example ya zile sehemu ambayo mmepitia na kuangalia kwamba the vast distance ambayo unaongelea na hali ya chochole. Chochole, Kiswahili kana ndaitisha fizi yangu. Chochole ni umaskini, si ndio? Sawa, wacha nirudi kwa ile Kiswahili nimezoea. So, can you paint for us a picture of these societies? How far could they walk or travel to get that document? Na wakitravel, je, wanaipata kwa siku moja au itabidi wakuwe na multiple journeys?
Yeah, hapo awali kabla hatujaanza kufanya kazi na hizi departments ama civil registration, kwa mfano hawa wananchi ambao kwa mfano Kwale, we have only 2 registration office. Moja iko Kinango na moja iko Matuga. Matuga tunaweza sema is the central business ya Kwale County ama the headquarter of Kwale County, and the other one is in Kinango, which is the farthest end, ambayo the constituency imeshikana na Tanzania ama imeboda not Tanzania but imeboda Taita Taveta. So mtu ambaye anatoka the farthest end, kwa mfano the Pemba community ambao tunazungumzia, wengi kabisa wanaishi Lunga, na Lunga is the farthest constituency ambayo imeboda Tanzania. So mtu ambaye anatoka Lunga na anataka kufika Matuga where the civil registration is, kwa sababu Matuga civil registration serves between Matuga, Msambweni and Lunga constituency. So huyu mtu lazima anaweza gharamika kati ya 1,000 kwenda na kurudi, hiyo ni 1,000 mwingine, hiyo ni 2,000. So wakati huo wa nyuma ilikuwa akienda hawezi pata hiyo siku, anaambiwa naenda rudi, akuje baada ya siku 14. So aende apange safari tena, baada ya wiki 2 arudi tena. So inakuwa ni safari ambayo naenda rudi. Kama sasa tunavyoongelea, katika ofisi ya civil registration kuna zaidi ya birth 4,000 hazijawahi chukuliwa na wananchi, kwa sababu mtu atakuja leo ataambiwa naenda ungojee baada ya wiki 2 ama mwezi, akienda tena naambiwa bado, so unakuta ana give up kutafuta hiyo birth certificate. Na ikifikia hapo mtoto anataka kuenda shule, maybe amefikia the age of 4, anataka kuwa admitted shule, inakuwa ni shida ingine kwa sababu ameapply amekosa, anabidi anaweza fanya tena maombi ingine ya birth certificate, so kuna kuwa na double registration. So shida ni the distance covered between hawa wananchi pale wanaishi mpaka the civil registration pale iko. Hiyo ni distance bado ni kubwa sana, yeah, kwa mwananchi kumudu, hasa katika uchumi ambao tuko nao.
Na ukiangalia ile kazi yenu ambayo mnafanya kama paralegal, iko na benefit gani katika both sides ya serikali na wananchi ambao nyinyi mnaangalia?
Naam, asante. Kitu ambayo tunajivunia kwanza ni ushirikiano baina ya shirika na ile idara ya serikali, kwa sababu tumekuwa na maongezi ambayo yamefaidi hizi jamii. Kwa mfano zile jamii ambazo zinaishi mbali, tumehimiza kabisa ile idara ya serikali kuhakikisha huyu mwananchi anayekuja, akikuja asubuhi basi aweze kukaa pale, ikifika saa 8 akitoka awe anaweza kupata cheti chake cha birth ama cha mtoto wake, kwa sababu hiyo itampunguzia gharama ya huyu mzazi na pia kuhakikisha anapata kile cheti. Kitu kingine ambacho pia kimetufaidi kutokana na ule uhusiano tumekuwa nao ni zile jamii ambazo kupata hizi documentation ni shida. Kwa mfano the stateless persons, kwa sababu lazima prove babake ama mamake iko na kitambulisho, lakini kupitia kwa mafunzo ama kuelezana kuhusiana na sheria vile ninavyosema, imefaidi hizi ofisi, hususan hizi jamii. Sahi akienda na ile birth notification without kutoa kitambulisho cha mama ama cha baba, still bado anaweza pewa birth certificate. Vile vile pia tumejaribu kuziwezesha kupata zile field outreach ambazo zimesaidia hasa zile jamii ambazo zinaishi kule ambazo ziko mbali na civil registration ama ofisi ya uandikishaji.
Mohamed, labda nikirudi kwako, kuna wakati ulishai kufika ukasema nimechoka, sitaki kitambulisho tena?
Ndio, kuna wakati nishai kata tamaa kabisa.
Na nini ikakurudisha katika kuanza kuapply tena?
Unajua kila wakati nilikuwa nikikuja naambiwa enda ukuja siku fulani, enda ukuja siku fulani. Sasa mimi nikafikia mahali nikakata tamaa, nikasema kama ID nitakufa kama sijapata ID ni sawa. Kenye imenifanya nirudi kushughulika na ID ni kutokana na kazi ndio imenifanya nirudi kutafuta ID.
Na pia kama kuna mtu mwenye anakusikiza saizi na akona uwezo wa kukusaidia kupata hiyo kitambulisho, ungekuwa na ujumbe gani?
Kweli ningepata mtu wa kunisaidia kupata ID, ningeshukuru sana.
Uko na watoto?
Ndio.
Watoto wako wako na birth certificate?
Hapana.
Wako na miaka ngapi?
Mmoja ako na miaka 6, mwingine ako na miaka 4.
Mbona hawana birth certificate?
Juu mimi sina ID.
Walizaliwa hospitali au nyumbani?
Walizaliwa nyumbani.
Okay. So you see, it's a compounding problem. It becomes a generational problem. I don't want to whine about the problem, but I want us to ask ourselves, when we go back to our corners, where is the problem? If our laws are clear, nasemaga sheria, the law is clear. Sindio? If our laws are clear, where is the problem? If Muhammad, by the virtue that the father is a Kenyan, cannot get an ID by the connection with the father, And now Muhammad's children cannot get an ID because Muhammad's status is unknown yet. So what is the fate of Muhammad? And I would like to end with two things. I always like to go back to Shakespeare and say, he says, what is in a name? That which we call a rose by any other name will still smell as sweet. There are people who, by the virtue that they are called Muhammad, they are called Mustafa, they are told these are not Kenyan names. But let us go back to the Constitution of Kenya, and we go back to the preamble of the Constitution. It says, proud of our ethnic, cultural, and religious diversity, and determined to live in peace and unity as one indivisible sovereign nation. Then ask ourselves, are we really proud of our diversity, while our diversity is used against us? Thank you very much.
Thank you, Mustafa, and the Namati community members. They've aptly put the challenges that they face, and it's not easy to be in that predicament. Now, the results of this community partnership between Kenya Law and Namati has been this publication that you have right here, and we're going to highlight it shortly. However, we have members who are watching us online. This event is being streamed on Namati's Facebook and YouTube page. The link has also been shared on My Kenya Law. That is the handle for Kenya Law on all social media platforms. If you have any questions regarding what has happened in the plenary or what will follow, for example, the next presentation on the contents of the book, kindly state your questions in the comments. And for the members, if you have any questions, the second agenda item after this shall be a plenary session that will be chaired by the Kenya Law's DCEO. So kindly note down your questions, and we have all the members and partners from the various governmental institutions that can provide us some nice answers to our questions. Now we're going to move over to the next agenda item, being the presentation of this book. Let's find out the contents of the Citizenship and Nationality Digest. In this, we'll be guided by Teddy Musiga. He is a senior law reporter at the National Council for Law Reporting, that is Kenya Law, and he shall present on the review and the highlights of the Citizenship and Nationality Case Digest. Teddy Musiga, karibu.
My name is Teddy Musiga, and I'll be taking you through the highlights of this book on behalf of the technical team that worked on it. And just before we shared there, but just before I say that, just to make other people understand what we do as Kenya Law in terms of law reporting is we select cases based on a 4-tier criteria. One, cases that make new law. So for instance, if the courts are confronted with a case and it brings new issues, and that is a case that will make it to the law report. 2, sometimes we have cases that modify an existing provision of the law. So sometimes we could have decisions that have already been reported in the law reports, but because it will find its way to the law report. 3, we have cases that settle points of law that have been doubtful for a long period of time. There are times, for instance, you'll have courts of concurrent jurisdiction, as we shall see from some of the slides that we have here, that they give decisions that conflict with each other. For instance, say a court in Kisumu says position X in a matter, a court in Nairobi says a different kind of position. Now, those kind of cases will also be highlighted and brought to the law report. And finally, we also report cases that are just peculiarly instructive, you know. They could be instructive in different ways. Say, for instance, it's a matter of public interest. It will find its way to the law report because of that peculiar nature of it. Sometimes the damages that have been awarded are very high. It would find its way to the law report. Or sometimes, even that case is just an issue that rarely happens. Like a couple of years ago, we had all these issues of surrogacy, which were very new and alien to us. Those are cases that find themselves in the law report. So now, back to this publication that we have today. These cases that we are going to discuss in the next few minutes fall in either of those 4 criteria. 1, they're either making new law. 2, they're either modifying an existing provision of the law. 3, they're clarifying points of law that have been doubtful. Or 4, they're just peculiarly instructive. And so when you move to the scope of the book, the next slide. The scope of the book just has about 5 areas. We are looking at case law on citizenship by birth, case law on citizenship by registration, case law on dual citizenship, case law on right to fair administrative action, and case law on identification documents. And finally, we have the last one on freedom from discrimination, digital identification. The next slide. The slides look really tiny. Is there a way we can, but maybe I'll be saying what we have there. When you open the book, I'm sure now we are really wondering what kind of cases you have inside this book. And the very first part of that book are talking about people who have either been denied citizenship, yet they were born in Kenya, or they found themselves born in Kenya as per the provisions of Article 14 of the Constitution. So for instance, in the first point there, for those who are unable to see it at the back, is that one of the cases you'll find in the book talks about citizens by birth cannot lose their citizenship upon acquiring passports from other countries. And of course, the reason for this is that citizenship by birth is a birthright and is a natural and untransferable right. With this case, this point, you'll find it in the Miguna cases that happened just very recently. The second case that appears there talks about in a situation where citizenship has been contested, okay? There are certain instances where people are just arrested by the police and then they're made to prove whether they're actually citizens of Kenya or not. And this is what happened in Kulraj Singh and Bangra case, where the court says that where citizenship is contested, then the act of applying citizenship is an admission in the first place that you're not a citizen. Okay, I find that case very controversial, but you'll get the real gist of it when we get the book later. Now, another part that features in part 1 of the book is on loss of citizenship by birth. All right, and of course, then one of the major ones, I would start with EWA and 2 others case, where the court has told us that if you're a Kenyan citizen, then you cannot lose your citizenship by birth. Then we have 2 other cases which are very recent. One, we have the Mwende Mwinzi case. This lady had been appointed as an ambassador by the president, had been nominated and proposed for appointment. But then when her case went before parliament and for vetting, the parliamentarians said because she owed dual citizenship with, I think, America, they could not confirm her. And they were saying that the Kenyan constitution, as much as it allows for dual citizenship, for purposes of state officers, then they cannot get appointment as state officers. So in that case, in Mwende Mwinzi, the court says that the only way one can lose citizenship by birth is by giving up their own citizenship on their own volition. Mwende Mwinzi was born in America, but the president now appoints her to be an ambassador to represent the Kenyan interests in America. So the parliamentarians are telling her, if you're still interested in representing Kenya as an ambassador, then you have to quit first from being an American citizen, and then we can consider your application. The same case happened in the case of Gama Duba Gufu, which even the CEO mentioned in his speech earlier. The point was the same. The court says the only way you can lose your citizenship is if you choose by yourself. And in the same case again, Mwende Mwinzi and Galma Duba Gufu, the court again emphasizes the same point and says that no one can be forced to give up their citizenship by birth of another country unless they voluntarily decide to do so. So it will be interesting for us to watch, for instance, Mwende Mwinzi, if she really wants to be an ambassador, if she's going to quit being an American citizen, and that's something we'll be keen to pursue. Thirdly, in the same part 1 of the book on citizenship by birth, we have an interesting case now, the one on Galma Duba Gofu, which says that if a person's parents are both Kenyan citizens by birth, then the person will be presumed to be a Kenyan citizen by birth. And actually, if you read the provisions of Article 14, I think Article 14, 1, 2, 3, or thereabouts, it says that the presumption is there for anybody who's found in Kenya. If you move to the next slide, We have then the next part of the book, which talks about cases on citizenship by registration. And these cases, one, they are found under Article 15, one of the Constitution, the cases that have gone before court. And for instance, this talks about, for instance, persons who are married to Kenyan citizens, yet themselves they are foreigners, okay? And sometimes they may want to get citizenship, or for other reasons, they've stayed in Kenya for like 7 years, they'd want to get Kenyan citizenship. And we have about 3 cases there that stand out. These are just representations, they're not all the cases that are there, okay? Some are in the book. For instance, the first point that has come up there under that theme is the SN case, which talks about conferment of citizenship to persons married to Kenyans is not automatic. You have to apply through, there's an act of parliament that regulates the procedures that you have to follow and everything. So the court says that the decision is discretionary on the authorities. They have to investigate as to whether such applicants are deserving, and also reasons have to be given why their applications have either been accepted or rejected, as what happened in the case of SN. Then in the case of Samira Tariq Qureshi, this talks about applications for citizenships ought to be processed in a timely manner. Okay, in this case, the court says a delay of 4 years is very long, and that one violates Article 47 of the Kenyan Constitution, talks about the right to fair administrative action. Then we have another case here, ex parte Patricia Olga Holson, who was also seeking citizenship by registration. And the main point there, the court was saying that provision of confidential reports about persons who have applied for citizenship by the National Intelligence Service is subject to the right to fair administrative action. In this case, the authorities had said that they'd received some controversial reports about this applicant, and therefore they rejected her application to be a citizen. But then they did not disclose to her. So she was just wondering, she's applying for citizenship, but nobody's telling her why her citizenship has been denied. So the court in this case says that they need to be given reasons why that should happen. Now, when you move to the next slide on dual citizenship, dual citizenship is found under Article 16 of the Constitution of Kenya. It allows Kenyan citizens to have dual nationalities with other countries as well. And here again, we have the case of Mwende Mwinzi coming out very strongly, together with the case of EWA and 2 others. And I think I've mentioned the brief facts of Mwende Mwinzi, what happened. And in this case, the court was saying that a dual citizen cannot be appointed to be a state officer because of the competing interests that a dual citizen may have. And there's an exception. There are certain people who can be appointed to state offices, even if they have dual citizens. People like judges or even members of constitutional commissions. We have seen even chief justices in this country who are foreigners. We have seen members of constitutional commissions who are foreigners from other jurisdictions, and the court affirms that point. Still, in Mwende Mwinzi's case, they say that state officers who acquire dual citizenship stand to lose their positions as state officers. So, for instance, you cannot contest for parliamentary seats, for president and many other state officers' jobs if you have dual nationalities. And in that case, the court urged Mwende Mwinzi to decide whether she wants to forfeit her American citizenship for her to get the position. In EWA and 2 others, the court says that persons who had lost their citizenship by birth by account of acquiring nationality under the repealed constitution were entitled to regain the citizenship by birth and upon application. This is found in Article 16 of the Constitution, which allows people who had lost their citizenship by whatever reason, okay? Under the former constitution, the law used to say that if you acquired another citizenship of another country, then automatically you forfeited or you lost your Kenyan citizenship. And so now the new constitution allows some of those people to come back, but in subsequent slides we'll see how the courts have been telling us different things about that very point on dual citizenship. On the next slide, we have emerging jurisprudence on citizenship and the right to fair administrative action. Of course, the right to fair administrative action under Article 47(1) of the Constitution requires us that for every decision that you make, it must be lawful, it must be efficient, it must be procedurally fair, it must be expeditious in a timely manner, and I think there's a 5th one, you must give reasons for all the decisions that you make as public officers. So most of these cases here, for one reason or the other, people who are applying for their citizenship, and for sometimes the officials will tell them, we cannot grant you citizenship, but they're not giving you reasons why. Sometimes the procedure is not fair. Sometimes the decisions take too long. Some people make the applications and they have to wait for 6, 7 years. Others have waited for even much longer, and even at the end of it, you have no guarantee of getting that citizenship. So the cases that follow here talked about the right to fair administrative action, and the first one is in Patricia Olga Howson case. where the court says that if you have confidential reports, then at least you need to provide reasons why you have not granted the citizenship to those people. In Samira Tariq Qureshi case, the court says this person had to wait for 4 years, and the court says a delay of 4 years amounts to a violation of the applicant's right to fair administrative action. In Jasvin Chandra Noratam, it's a very long name, the court says that persons applying for dual citizenship had to follow the right procedure. You cannot just wake up and say you want to be citizen. When one had lost their citizenship under the old constitution by acquiring citizenship of another country, then such persons had to follow the right procedure to reacquire their citizenship back. In EWA, I've mentioned this case before. The court says that persons who had lost their citizenship by birth by acquiring nationality, other nationalities, are entitled to regain their citizenship upon application, and citizenship by birth could not be lost. And finally, 5 years was found to be an excessive delay, like what happened to the applicant Kulraj Singh Bangra. The same happened in the case of ex parte Patricia Olga Hawson, where the court says 6 months is a very long time in considering an application for citizenship. The court says that was unreasonable, and court ordered that the relevant officers to issue all the relevant necessary documents to facilitate her registration as a citizen. In Elgal Mohammed Osman case, the issue was that the authorities had taken more than 3 years, and the court says that a delay of 3 years is very long in processing application for registration of citizenship, and that is unreasonable. Again now, in Miguna case and Bashir Mohammed Jama Abdi case, the court says that when handling disputes on citizenship, regard must be made to the due process, legality, and reasons must be given. Basically, the court was making this case based on Article 47 of the Constitution. Now, those are samples of the local cases that we have in the book, but there are many others. I was just giving the main ones that stand out based on the 4-tier criteria. Now, when you move to emerging jurisprudence on, I had not finished the local ones, emerging jurisprudence on national identification, we have a case, this was among the earliest cases on Muhuri. I think it was around 2011 when the new constitution had come and people were trying to test the new provisions that we now have. And this case concerned Asians and Arabs who had been denied citizenship. The facts are almost similar to the Nubian children case, which we have heard even from the panel that we just had earlier. And in this case, the court was saying that courts only have jurisdiction to review decision-making processes concerning application for citizenship or processes. They're saying the entire process depends on the authorities that we have. And in the event that they do not follow the law, that is when the court can intervene. Then we have Abdikadir Salat, where the court says that even where one was a Kenyan by birth, should one register as a refugee for whatever reason, then the court is not in a position to order for that person the court is not in a position to order for that person's citizenship status to be changed from refugee to a citizen. What was happening in this case, that there are certain people who, because of certain reasons, they may want to be declared refugees to get certain benefits, but then later on they realize, I no longer like this status of a refugee, and I want to be a citizen. So this case represents many of those that are also in the book, of people who've suffered a similar fate, and the court tells them, we are sorry, the moment you've been declared a refugee is a legal status, there's nothing we can do about it. Then there is the Muhuri case on behalf of the 40 others, which had mentioned this was a case concerning the Arabs and Asians who had been denied citizenship. And here the court was saying a court of law cannot assume powers of immigration and internal security authorities. A court of law can only declare one a citizen. A court of law cannot declare one a citizen, nor could it grant national identification travel documents on a aggrieved party. A court of law can only review the decision-making processes and give the prerogative orders on the process. So you really have to go to the agencies that we have to have your cases looked at. The next part of the book talks about emerging jurisprudence on digital identities and freedom against discrimination. Just recently, in the last few years, we had the Huduma number. And again, this case was brought by the Nubian Rights Forum. And the court said a number of things about the Huduma number case. And one, they were saying that government should not compel any other member of the public to participate in the collection of personal information and data in the names. And of course, you can tell why this order was coming from. Even from the panel, we've just had the reason. People are saying they're unable to get these documents. So you can imagine, on the one hand, you can't get these documents, and on the other hand, you're being told you must register, all right? The next order the court gave there was that government cannot set any restrictions or deadlines as regards the collection of the said personal information and data in the names. Government not to set the collection of personal information and data in the names as a condition precedent for the provision of any government or public services or access to any government facilities, and also government not to share any personal information or data collected in names with other national or international government or governmental agencies with any person. Now, there's the Nubian children case. This case went before the African Committee on Rights and Welfare of the Child. And just from what we've even heard from the panelists here, these children have been facing systematic discrimination from independence to date, okay? And so they're going to the African Committee on Rights and Welfare of the Child, and they're saying that for us, when we reach the age of 18, we apply for our IDs, we are asked very many unnecessary questions. You're asked who is your grandfather, who is your grandfather's grandfather, and when did you come here, and all those kind of things. Yet every other Kenyan just simply goes to the chief with some forms, signs somewhere, and leaves with an identity card after a few weeks or months. So this case went before the African Committee on Rights and Welfare of the Child, and the committee gave orders to the government of Kenya to do, but unfortunately, they're yet to comply, though in principle, they're saying they should be given, but in practice, these people are still suffering the same fate. Now, the last part of the book talks about international and comparative jurisprudence on citizenship and nationalities. And the first case is a very old case of Lechesten versus Guatemala. This is a 1955 case, very old case that was talking about genuine link. In Lechesten versus Guatemala, the main party there, if I remember the name, was a gentleman called Mr. Nottenbaum. And Nottenbaum had been a citizen of Germany, but then during the war, he relocated to Lechesten. At some point, Lechesten was fighting with Guatemala, and he also moved to Guatemala. And then at some point, again, Guatemala and Lechesten were not friendly to each other, and he needed protection of one of them. So he goes before the ICJ, and the ICJ says that for us, we need to establish a genuine link. Can we really tell? Are you German? Are you from, what do we call people from Lechesten? Lechestenese? I don't know. How do we pronounce that? Or are you from Guatemala? It's a very interesting case that you'll find in the book where the court says that Lechesten had no right to bring this case on behalf of Mr. Nottenbaum. Then we have an interesting case that I've liked for many years, the Unity Doe case in 1994. Unity Doe was a lady in Botswana. This lady was married to a foreigner, and she wanted to confer citizenship to her children, but the law said she could not do it. We used to have a similar law here. Now things have changed under the new constitution. And so Unity Doe went to sue. What I like about this case is that Unity Doe represents the diversity in the society. It is not only the less privileged people who suffer such kind of things. Unity Doe, I think, is a sitting member of parliament in Botswana today. But as of 1994, she was just a practicing human rights activist and all that. And you can imagine she also went through that challenge of conferring citizenship to her own children. Then you have a case from the African Court of Human and People's Rights, which is in Tanzania, on Robert John Penesis versus Tanzania. It's a recent case of 2015. In this case, this gentleman was arrested. Then after he's arrested, he's being made to prove that he's a citizen of Tanzania. But he says, you arrested me, I've always been living here, I'm a citizen of this country. And the African court agreed with him and actually said that the Tanzanian government was violating his rights to nationality. We picked that case because it represents, perhaps I should have said, Lechesten represents cases from the global level. There are others in the book. Then we have Robert Penesis representing cases from the regional level, the African region. So it comes from the African Court on Human and People's Rights. Then we have certain cases that come from national courts but have been very persuasive. Remember the 4-tier criteria I said earlier, the 4? Now these other ones fall under that category. One, you have a case, Yamikani Chisuse case of 2019 in South Africa. And this case that says that a citizen by birth is one who is born to at least one South African parent. You see the current position that we have now even in Kenya, you really don't have to have both parents being Kenyans for you to be the citizen. One is enough to confer that citizenship to you. Then you have a case from Lesotho, Melato Caleb Mokoena case of 2005. In this case, the court says that according to Lesotho law, someone could lose property rights on account of dual citizenship by acquiring citizenship of another country. Why we pick this case is because it's similar to the practice that we had in this very country before the 2010 constitution. Then I've mentioned about the Nubian children case that went before the African Committee on Rights and Welfare of the Child. I put it as international, and I put it last because in a way, I didn't feel it is international because they're part of us, you know. These are our people. But because this case went before the African Committee, it found itself in the book here. And also the second one, which now concerns the Nubian community in Kenya. These are now adults. The first one were children. These ones are now adults. And this case went before the African Commission on Human and People's Rights. And in that case, they're also talking about discrimination in access to nationality and arbitrary deprivation of their nationality and breach or respect of their property rights. They're very interesting cases. And the more reason that we are all Kenyans, it would be good for us to know those last two, the Nubian children's case and the Nubian people's case for the adults. The next slide then talks about the things that came up as you are compiling this book. As part of our work as law reporters, we are required to identify issues of law reform for the purposes of improving and enriching the law. And sometimes when you do that, we also encounter cases that give difference in judicial reasoning. Difference in judicial reasoning basically means that it's a very diplomatic way of saying some judges contradict each other, all right? So we don't want to look very controversial. So we say they differed in how they reasoned in this case. And one, there's the controversial issue of loss of citizenship. We have seen from the cases that I've highlighted, some cases say that you cannot lose citizenship by birth. Yet at the same time, some courts say when you lose citizenship by birth, you need to apply, all right? So the question then becomes, like what we had in EWA case, that one cannot lose citizenship by birth. And two, Mwende Mwinzi is being told that because you're born in America and you really want to be an ambassador representing the Kenyan government somewhere else, I think it was Korea, the court now tells you, you need to reapply for your citizenship. Of course, that provision is there under the Constitution, Article 16, but the kind of cases that we're having from courts seem to be different. The next one is persons who lost their citizenship by birth are entitled to regain their citizenship and even have dual citizenship, provided they apply following the correct procedures. We saw that in EWA case. But in Miguna's case, the court says that there is no way a citizen can lose their citizenship by birth, and therefore there is no need to reapply for that citizenship. I found that really contradictory, because if you look at Article 16, it says that people who had lost can reapply. But here the court says we cannot even interrogate the argument that he lost. There is no way he could have lost that citizenship. He's Kenyan. Then the next part that we saw had differences in judicial reasoning were the issues on the procedural safeguards on the Fair Administrative Action Act, and the question that the courts are asking here, how long is unreasonable delay? If you apply for citizenship and the court takes 6 months, have they delayed your application? If you apply and they take 3 years, have they delayed? As in Egal Mohammed case. If you apply and they take 4 years, have they delayed your application? If you apply and they take 5 years, like in Kulraj, have they delayed your application? Now, these are questions which, of course, you do not have answers as law reporters, but we put them there so that it can enrich the debate and you can develop the law further. That is the brief highlight of the entire book in very few minutes. And I'll end there. Thank you so much.
Now, after having such a nice highlight of the book, I'm sure most of you are, bubbling with questions that you want to ask regarding the book or regarding the presentations that you've had today. Regarding the book, we'll be having the person who actually steered the entire editorial process, the DCEO of Kenya Law, Janet Munyoki, shall be here. And if you have any questions regarding the book, now is the time. And if you're there online, you haven't received any comments yet. I'm sorry, the comments are disabled, but now they're enabled. If you have any questions, just put them in the comments. I shall be monitoring, and we shall present them. And if you have any questions towards the book, now is the time to ask. The mic will be passed around, and we are observing COVID protocols. They are being sanitized after each person holds the mic and talks on the mic. That way we can, maintain that this monster of COVID is not here amongst us. So, DCO, the floor is yours.
Thank you very much, Ribia, Teddy, Mustafa, and of course, our leaders who spoke earlier. Good morning. I'd like us to stand up, stretch yourself. It's been quite a morning. And this is the time you market yourself. So look at your neighbor, give them a namaste greeting, and tell them who you are and where you work. You can exchange cards if you have any. For those who are seated alone, you can wave. Yes. Yeah. Sometimes you go to forums and sit and leave without even knowing who your neighbor was, isn't it? Okay. I just said two things. Just say your name and where you work. But now I'm seeing others are even extending. We'll have a forum later after the launch to continue the conversation. Sawa sawa. Okay, have your seats. And thank you very much for being here with us. It's really a momentous occasion for us and Namati to be sharing and actually making public what emerged from this case digest that speaks to quite pertinent issues that affect all of us. We all know a neighbor who who suffers or who has challenges of this kind of nature. We come from families where we have experienced this, so it's a matter that affects all of us in one way or another. And therefore, it's really a privilege for us to be here today. This is a plenary session, as Ribia mentioned. If you have mentioned earlier, if you have any questions, we'll be having a roving mic going round. But I would also like to acknowledge the government agencies that are present here. Remember, in our work as Kenya Law, we partner a lot with government agencies because we are one of them. And therefore, by them accepting to be here, and particularly those that work on these areas, we really appreciate them. I can see Dr. Mogesa from the National Commission for Human Rights. He's the CEO, Secretary. Karibu sana, Daktari. Miss Elizabeth Choge from the Immigration. Yes. Minister of Foreign Affairs, thank you very much, Madam, for joining us. And then we also we have Shumeri from the Civil Registration Services. Thank you very much, sir, for being here. And we are hoping that even as we interact in this session, we'll be as participatory as possible, so that then we can gainfully gain from the insights of the book, but also in terms of the practice and challenges that emerged. So in a nutshell, going back to the session that was chaired by Mustafa, and we are very grateful for that community focus, because really that is where the rubber meets the road. These are the challenges and in terms of practice, in terms of how important it is, and this really is where we have to make a decision and identify whether our laws are working for us. And therefore, Amos and Abdullahi did bring that out very strongly. Abdullahi mentions that the application process for being a citizen is not easy. Indeed, if our constitution says that so long as one of your parents is a citizen by the time you're born, then automatically, that makes you a citizen. We have seen those challenges, the challenges of being born and the generational issues, problematic issues that emerge from there have rightly come out as an area that we need to look at. In terms of what Amos brought out and the important role that paralegals play in the society, he has mentioned that they have been able to identify communities that have these challenges. He spoke about the Pemba community. And what came out is that the issue of double registration, distance, really, in terms of access to justice. If our constitution says it should not be a hindrance, then the question is, how easily accessible are our government services in this particular area? He brought out the elements of partnerships with the government, which is quite good, because he was able to bring out that there's been positivity in that angle. And they've been able to assist communities that have challenges in this area to actually be able to counter or go, access these documents, even when they are required to provide a little bit more documentation for identification, such as the birth notification and IDs of the parents. Field outreach came out strongly as also an area that has brought out positivity, where communities then learn from each other, and those that have similar issues are able to assist one another. So the element of community, quite important, because that is where, as I mentioned earlier, our laws are tested. Teddy brought out in detail what the digest is about. There are 29 cases in total, sampled out of more than 100 cases, but particularly just limiting on these two areas. Of course, there are so many other areas that touch on these citizenship rights. And he was able to take us step by step. Articles 14, 15, and 16 of the Constitution, which ideally we should all be aware by now what they contain, and the cases that have emerged, including those that have been able to test the law that is applicable, the issues of processes, communities understanding process. In one of the cases, the court mentions that when there is unreasonable delay, without decisions being made by the respective agencies, then it's very difficult for the court to determine, to assist that particular applicant, to determine the issues that they're going to court to seek. Therefore, unreasonable delay continues to be an area that must, our justice agencies must look at overhaul. Host community is very interesting, and I remembered this is very common in communities which are near the refugee camps, where you find they will register so that they can get rations, can get support from the international agencies. Quite a highlight moment there, and the repercussions, because upon that registration, then the presumption is then you are denying yourself your birth or your citizenship rights. So that really has come out strongly. Law reform issues, of course, we appreciate, even in our work, that a judicial officer, working in a certain region and another one working in another region will face similar cases, but in putting their minds, because they have a right to discretion, they can be able to conflict in settling some of those issues. So it's our work to identify this, and this process of putting together this case digest has given us more work, because now we are going to reach out and highlight these are the differences that we have noted, and that the judiciary needs to agree on a common approach to guide all of us. And of course, the issues of lost citizenship, quite critical, including also the procedural safeguards on what is reasonable time. And a lot of cases actually have been able to look at that particular area. It's not been, because our constitution just says it needs to be within reasonable time. And the most interesting aspects of it was that even when the court made a decision, they would say within 30 days, give feedback to this particular applicant. Within 6 months, 4 years is a long time, 3 years is a long time, 6 months is a long time. So that area is really gray at the moment, and we are hoping that sooner or later, some of this will be determined for the sake of enabling access to justice during the administration of justice by the justice agencies. So in a nutshell, those were the highlights that came out of the two, during the two panel discussions that we've had, one which was a PowerPoint presentation, and the other one which was a community moderated session. I would like to hear from you. So if there are any, if there's anyone with a question, really this is the moment. I'd like to give a right of response also to the government agencies who are with us. I'm sure I would love to hear your feedback on this, clarify maybe some of the areas, or let us know in case there are certain things that are happening to ease the challenges that have emerged in this process. We are happy to listen and to hear from you. For the online viewers, Ribia, you will monitor that? Okay. Dr. Mogesa, you want to say something?
Thank you very much. From our perspective as Kenya National Commission on Human Rights, I wish to state that each day we are confronted by issues of citizenship. In fact, 2 days ago, a South Sudanese refused to leave my office because he wanted his, a case about his application for citizenship, considered. And of course, our immediate response was that we do not deal with this. We have other, government agencies, and all that we can do is to give, a referral on such cases. But as a commission, and thank you very much, Kenya Law, for the good work that you do. We reference all this even in our publications, even in our research. So this is very, very important. But one of the areas of concern for us as a commission, again, revolves around, impunity many times, total disregard of, court orders. For example, when you mentioned the Miguna case, which as a commission we were actually, we were following all through, because again, we have a mandate to ensure that the rights of Kenyans are protected. So we will constantly raise issues around, impunity, total disregard of, court orders, which I think as a country, we really need to rethink about this. And then finally, advocacy around citizenship, takes a very long time. We have been working with communities, the Makonde, for example, you know very well, and the period of time that we really advocated for their consideration for citizenship. So citizens need to understand, or foreigners need to understand, that advocacy takes a long time. And therefore, many times, sometimes, paperwork and all those considerations sometimes becomes very, very challenging. Finally, Northern Kenya, you know very well, the challenges of even, the students after, completing school, getting national ID cards, for them to be able even to proceed to college is a challenge. And I think as a government, as a country, we really need to reflect on our approaches and processes that can guarantee those citizens, genuine citizens, to acquire those registration papers. Thank you very much, and again for the good work, Teddy. Thank you very much. I wouldn't waste time, reading this after you give me a copy. Thank you very much.
Yeah, thank you so much, Dr. Mogesa. And maybe I have just one question, and we acknowledge the work that the Commission has done consistently over time, and the successes, the Makonde, and amongst others. And since we also use these forums to also learn from one another, it's important also that those best practices are shared. So that also communities can embrace to see, is it closer networking and partnership with government? You mentioned that advocacy takes a long, long time, and indeed it does. Is it that it needs to be informed advocacy where the law is particularly broken down, and that the advocates or those that are advocating for a certain issue go out and they are able to bring out these issues with certainty? What is it that we need to know in terms of, conducting a purposive advocacy that brings results in this particular area?
Once again, what I can say is that you need a structured engagement, involvement of the relevant state agencies. For instance, the Kenya National Commission on Human Rights, realizing that we could not detach ourselves from matters immigration, we had to come up with a program on better migration management. And therefore, we went to the immigration department, and then we started, also to understand how immigration works, for instance, so that even as we advocate, we are doing it from an informed, perspective. So through programming, that is very important and significant, and also working with the government agencies to also understand the requirements, such that then when you are advocating and reaching out to the various applicants, then you are able to give them the right information. That's the approach that the Kenya National Commission on Human Rights is using at the moment. And that BMM program, which I have mentioned, has really, worked. We are able even to share information, share concerns, cases, that come to us as a human rights, defender, and then we are able to relate to the immigration, and it is really working. Thanks.
Very much. Thank you very much. Yes, we have a hand. A fair lady at the back.
Thank you. My name is Frida Kabatsi from Catholic University. Thank you so much for the digest. It has raised very important issues, and I was just thinking, we don't even have a unit on citizenship and nationality, which is very problematic, because if you think about the importance that's attached to it, we should be teaching it in universities. So first, to congratulate Ms. Janet, Professor Mwimali, and Namati, but to encourage you to come to universities so that there can be advocacy on these rights. Thank you.
Thank you very much. Frida of Catholic University. Of course, we embrace partnerships, and I know we'll be reaching out to you soon. Yes.
Thank you. Hello, it's clear now. My name is Julius Angwenya. As I had said it, first and foremost, I want to thank Kenya Law and Namati for making us come to this place. It's a very good move. We are headed to the right direction. And secondly, I would like to ask Namati whether they are aware that the Nubians who are living in Kisii are experiencing a lot of challenges, that as it was highlighted in the media recently, and what have they done about it? Then secondly, I will ask the agency, a government agency that is responsible for enforcement of the orders of the court relating to citizens and nationality, why are they not making sure that they have complied with the court orders that are given? Thank you.
Thank you very much, Mr. Julius Agweni. So a question to Namati. Would also would like to hear from our government representatives. Any other question before we get the answers to that? Okay, Laura. Oh, sorry, there's one more question. Gentleman, just, yes.
Good morning. My name is Yasa Musa from Nubian Rights Forum. My question cuts across, there has been public participation a few days ago on issues related to Huduma Bill. And my question will just be, what has, because I understand Namati and the partner organizations have been working closely with the community to make sure the Huduma Bill is all inclusive. But what has Kenya Law and Kenya National Commission on Human Rights and also other government entities doing to make sure that the bill is all inclusive and to make sure that what we are discussing here is actually something that won't haunt us in the near future? Thank you.
Thank you, Yasser, for your question from the Nubian Rights Forum. One more before we get responses. Yes, Joyce, good to see you from Christian Lawyers.
Can I just say this is amazing, the Rights Case Digest. Thank you very much, Kenya Law and Namati. My question, I'm in the space of legal aid, and I would like to know whether this is the digest is available in Braille, in Kiswahili. I also just want to find out, now, even for a student, you would have to navigate and learn how to interpret it. And I wonder whether there is a simplified, or whether maybe perhaps there could be recommendation for simplified kind of books, where then if for the person, when we're looking at the population of Kenya, how many people will actually be able to read and understand this? So maybe that's my own recommendation, that they should also be, and I wonder whether there is a simplified form. Thank you.
Thank you very much, Joyce. Simplification of books, very important, and whether it's available in Braille or Kiswahili. So going back to the questions that have been asked, Julius was wondering whether Namati is aware about the Nubian community in Kisii and the challenges that are impacting them, and what, if any, what they have done in that respect. Laura or Mustafa? Okay, so we'll have Mustafa.
Yes. I'll talk as a Nubian first, then I can talk as Namati. The issue is not about Kisii alone. We have Nubians in Embu, in Meru, Eldama Ravine, Kisii, Kisumu, Kibigori, and the coasts, Mazeras, and they go through the same problem in terms of exclusion, in terms of development. The settlements that they stay are all not well developed. The state of health is bad. The state of economy is bad, and all that. And nationality rights discrimination is the same, constant. Yes, we are aware. We actually have a paralegal program in partnership with the Nubian Rights Forum in Kisii, because we cannot have a paralegal per area, per person. What we are trying to do is, can we have sample cases that we can use for advocacy? And like today, Abdullahi is a case study. And we don't want him alone to be assisted. We want to have comprehensive solutions that will address the systemic injustice. So we are trying to address the issues of Kisii, and we have a paralegal there. And I'm aware the Nubian community is maybe going to make a statement about this over the weekend, because Honorable Matiang'i was given 90 days by Parliament to recognize the Nubian community. And it elapsed on the 21st. And nothing has been done. So basically, these are the things that we are following up. And as Namati, we are actively working with partners to see how we can address the systemic challenges of the Nubian community, Somali community, Swahili community, and other communities, so that we don't just address by case-to-case basis. Yeah.
Thank you very much, Mustafa. And perhaps maybe to Mr. Julius, is there anything that you're doing in Kisii to support this particular community? And are there opportunities available for partnership, as Mustafa has mentioned, and of course with other government agencies available to make the situation a little better?
Thank you very much for the question. We as a university, as one of the externship programs, we have been visiting and seeing how we can be helping, especially in provision of the basic needs like food, clothing, and sometimes even ensuring that the children who are suffering there, they are receiving medication from the university. That's what we are doing.
Very much. So those networks are quite important. I believe even with the paralegals in the field, in the communities, that concerted effort, and of course advocacy would be critical. Mr. Yasa from Nubian Rights Forum wondered what is being done on the Huduma bill, and particularly to ensure that it's an inclusive process. And that it's able to cater for the needs of the citizens or citizenry, if you may, in that respect. Do we have, and I want to throw it back to the plenary, any stakeholders that are working on that area? You're free to share what you have been doing around it. Katiba, any interventions on Huduma? Yes, and we have Chris at the back.
Good morning. Chris Kirkering from Petit. Think we recently had a meeting actually over the weekend to discuss the Huduma number bill, as well as some public participation that was ostensibly provided by the National Assembly. And I think many of you know that the sense that came out of that public participation was not necessarily that there was progress made with the Huduma number bill. And so what we are looking at, along with the rest of the civil society community and community-based organizations, is what to do on the legislative level, but also if there's going to potentially be something necessary as far as filing a petition. Ideally, we would like to be able to work with the National Assembly to make this better. I think that's what everybody would hope, but we also need to be realistic about what will be coming out of this. And I think that one of the good things we've seen is that there are now a large group of people who are aware of this bill and who are really able to speak about it with some expertise. And that's going to do a lot both for us to challenge the National Assembly and their agenda, but then also, if necessary, to push forward with litigation.
Thanks, Chris. And from the perspective of Katiba, what are the problematic areas that you're looking at here?
We still have problems with the use of the identification numbers as a way to really almost as a tag for surveillance. And we do not think that there has been the kind of survey and work done under the Data Protection Act that is necessary, that was really just lip service to those requirements. And we also think that this has really become an issue relating to national security, as was stated by the civil society organizations. And those are things that we need to look at. I don't think that fundamentally they address, the Huduma number bill addresses the problems that communities like the Nubian community are facing. That this is not going to be something that allows them access to the rights and services that they need. It's not going to fix those problems, and it's not even really intended to, is our concern right now.
Thank you, Katiba, for sharing those perspectives. Thank you very much. Any other agency? I'd like Dr. Mugesa to speak last. Yes. Okay, then Dr. Mugesa.
The question here is, what are we doing as Kenya National Commission on Human Rights? Of course, we are reviewing that bill, and we will provide an advisory to the National Assembly, as we do, to the other bills that come, to us, and especially those we feel that will infringe on human rights principles and standards. And of course, I agree with Chris in terms of the areas of concern, profiling, for instance, of individuals under the guise, even of terrorism, among others, surveillance, of course. And what's even worrying is how is this information and data, going to be managed? You've seen citizens raising concern about them finding their names under, registration of political parties. I found myself in a political party which I have never known. I do not even know where their offices are, but I found my name that I'm a registered, member of that political party. So as a commission, of course, we'll do that and get still space in Parliament for an oral submission of the same. Thank you.
Thank you, Dr. Mugesa, and yes, we look forward to that advisory. Any other last minute comments? I see Amnesty in the room. Yes, sorry. The mic. Please pass it.
Good morning. Yes, I hope I'm audible. My name is Jean Keraka from the Kenyatta University. Yes, I can see the presentation was good, and I have a question regarding the digest. And my question is, seeing that the problem is implementation of court orders and impunity from implementing agencies, does the digest have practicable solutions for encouraging implementing agencies to comply with the court orders? And do we have issues to do with national security? Because I would think that that is one of the reasons contributing to the laxity in implementation of the court orders that are given out or meted out for protection of the rights of those people seeking citizenship. So I've not read the digest as of now, but my question is that, do we have these practicable solutions apart from the cases that have been said, so that it can inform decision making going forward? Thank you.
Thank you very much, Jane from KU, and we'll be coming back to your question shortly. I had wanted us to first finish on that Huduma bill and what others are doing before I can invite our CEO to mention in terms of our role on publication of bills. Is that a question, Yasa? Okay. Is a comment? Do you want to come last? You want to come last? Okay. Amnesty International, anything that you're working on around this area? Shanice? Yes, please.
I'm Rajab from Amnesty. We are working on the Huduma number, as Christina said, and last week we were in Parliament to just submit a memorandum. We are just, our concern is on the privacy and data protection issues, and that's what we are trying to fight off.
Thank you very much. So privacy, surveillance, data protection. The Act was enacted in 2019. We've seen quite a lot of public participation happening. I think recently, last month, the regulations were passed. So it's really, really an area that mandates all of us to, participate in to ensure that our rights are protected. Yes, sir. You want to come in at this point?
Thank you so much. What we are doing as Nubian Rights Forum, also in partnership with organizations like Namati is we've been mobilizing citizens, especially the affected communities, so that they can be able to speak and raise their voices. But one of the biggest challenges that we're already experiencing is it's only minority groups that we've seen them working more towards this issue. But when you look at the way we are discussing these issues, it's not only affecting the excluded communities. It's issues related to data privacy, and these are the things that we really need to talk about. Giving an example of Member of Parliament from at the coast, Nyali, he has been suspected that he's supporting Al-Shabaab. So bearing in mind that all this information and issues of surveillance, if all his information will be taken by the government, by a press of a button, without his excuses and his explanations, they can just say he's Al-Shabaab and they have evidences. So these are the things that we really want to see are happening and the protection of Kenyans. The last one is the public participation that happened last week. It wasn't inclusive because the people we are defending, the people who are working on the stateless communities and the communities at risk of statelessness were unable to even get into the parliament to raise their views. So if it is public participation, how sure are we that they have included everything? Because the way it was done, we feel it was discriminating because you need to provide an ID for you to get inside. Those people whom we are fighting for, many of them do not have these documents. So if this team, at least as we are talking about the case study and the digest, we make sure that at least we come out, support our efforts, and also work together towards making sure that the parliament comes up with a good report and the state implements all the acts that we want. Thank you.
Thank you very much. Yes, sir. Public participation, quite critical. Mustafa?
I just wanted to bring to your attention that over the weekend, last weekend, Namati, KHRC, Immigration Department, IBC and other stakeholders were in Naivasha with the Committee on National Security and Administration. And it was so clear that all these departments are not speaking to each other in terms of the bill. And the resolution that we came out with is that this bill needs thorough reworking. And we are not ready to rush it. And we know right now we don't have an opposition. So the only people who are sober enough are the people implementing it and the people who will be impacted by it. So as organizations working around these issues, we decided to petition Parliament for the withdrawal of the bill. So we submitted a petition on Monday, if I'm not wrong, it was Monday. We submitted a petition on Monday to Parliament so that Parliament considers the withdrawal of the bill and recommends the constitution of a working group that comprises the government agencies, civil society and other government agencies, so that we could come up with a better bill that will protect all these issues, because issues of data protection, exclusion, and surveillance are very critical. And right now, even the aspect of one of the concerns was, if the bill passes as is, we might be in a standstill when someone goes to court and says, this bill says IBC should use Huduma number for verification. IBC is not ready to use it. So basically, we could have a stalemate where someone could say the presidential results should be nullified because the laws that should be used is Huduma bill. So basically, for the prevention of such situation, and we don't want the country to be in a dilemma come August this year, we are proposing that the Huduma bill to be withdrawn from Parliament, it be reworked completely, and then be brought back to Parliament when we have a better comprehensive bill. So that petition is at Parliament. We are waiting to hear about it. But because we wanted to be safe on both sides, we decided to also participate in this public participation, because you never, it's not a sure bet that the petition will be accepted. So basically, we wanted to have an impact in the bill so that we don't we are saying that, can we do resuscitation of this bill? Failure to it, if it dies, the better will come up with a better bill. But if it goes as is, could we do some bit of a stay while waiting to go to court? because that is also on the table. So basically, we are trying all possible avenues to make sure that this bill could protect the rights of all Kenyans, not only minorities. Thank you.
Thank you very much, Mustafa. So there are also petitions, before Parliament. All this is very critical for us, even as we are interested parties as citizens. Behind you, Jennifer. The last, we can close out on this.
Hi, Mariam from Haki na Sheria. To add on to the issue of the Huduma Bill, you would find that it does not necessarily address the issues of citizenship and nationality rights. For example, there is no administrative action to now take into account the fact that, yes, there have been people who have had issues accessing their nationality documents. And also, when it comes to the particular clause 10, that states that when somebody is trying to enroll into the NIMS database, they appear before a NIMS officer and issue the such documentary proof as may be required. That's quite vague. It takes you back to Schedule 1, and when you go back to Schedule 1, there's nothing there are no documents that are listed. So that would mean that going forward, it would be an arbitrary thing that would subject people, like for example, I'll give an example of myself. When I was trying to get my ID, I would have to go through vetting, which normally is not something that is supposed to be the case. It means that even going forward, since you can see those documents have not been, the documents that are required to be presented have not been listed. Going forward, it gives people the option to, these are the procedures you can take instead. So things like that now go on to further perpetuate and perpetrate the already pre-existing issues that the bill itself is saying it's trying to amend and look into. So maybe there should be a bit more, public participation, as has been said. Thank you.
Thank you very much, Mariam. And now Kenya Law Ribia has had a contribution, and Professor can conclude for us.
My contribution is regarding the question from the lady from Kenyatta University regarding the issue of national security. The gentleman at the back in the white t-shirt right next to the light also brought it up. So in the book, there's one case on that regard. It says that the provision of security reports about persons who had applied for citizenship who were among the functions of the National Intelligence Service. However, the provision of security reports was also subject to the right of fair administrative action, and delaying the release of such a report for unnecessary and unjustified period of time will amount to abuse of power. The case is Republic versus Cabinet Secretary of the Ministry of Interior and of National Government, and two others. So if I can just explain it in simple English, what the court said is that one cannot be denied citizenship on the guise of that somebody's file is confidential because they are part of a national security report. So they say that these documents are subject to the right of fair administrative action, so that if you go to court, the file should be presented to you and to the court so that the court may review it. So that's what we have from the book regarding the issue of national security. If you go through the book, you'll find, I think there's another case towards that effect, but it has the same ruling. Thank you.
Rebia, Professor.
Thank you, Janet, for that opportunity. I just want to speak a bit on our mandate. And we have attempted to at least ensure that that information on the laws that are in process of enactment are known to the public. So what we have endeavored to do as an organization is to actually publish even the bills before they come to be enacted and therefore become law, so as to ensure the public know about it. But beyond that, we want to also partner with all these entities and organizations, so that if there is need, for example, and I thank participants who have raised issues on how better we can do. For example, just going to look at the book and apart from the Braille and other format of publication of those documents, we also probably synthesize, as the lady from Kenyatta University said, so that we make this information easily available to the members of the public. We are actually looking to partner with both government and non-governmental organizations to ensure that we act on the basis of information that is valid, that is accessible, that is clear, that is veritable. And that, I think, for organizations like Namati who have partnered with us, is one of the ways of ensuring that these rights are enjoyed. So we are looking forward to greater partnership. And we thank you all for having come to participate on this, and we hope we'll do it even at greater depth. Thank you so much.
Thank you, Professor Mwimali, for those concluding remarks on that session. Joyce had asked a question about availability in Braille and Swahili. Perhaps maybe that's the next project, Laura. So we are saying that it's not available in Braille and Swahili, but it's very, very simplified. We've attempted to simplify the legal language that we normally use, in court. And I know the team that has been working, we had it challenged us because, as Professor has mentioned, we really wanted the document to be understood at the lowest levels, including referring to the Black's Law Dictionary and what it says, and then translating that in how palatable it could be as we continued to put together the book to ensure that it speaks to the common person at the lowest levels. Jen, I believe your question was answered by Ribia, and I believe also there could be many, many others that perhaps have not been raised, but I wanted to give an opportunity to Ms. Elizabeth Choge from the Ministry of Foreign Affairs to tell us something, because a lot has come out regarding, what is the role of government in respect to these orders that come. And we've heard a lot about fair administrative action. And when our constitution talks about that they need to be expeditious, lawful, easily accessible, what are those? How do we break down those terms so that at the end of the day we are seen also to be responsive in that regard? And then finally, Shumeri, I'll also give you a chance to tell us what you're doing around this area of civil registration, which will be quite important for us to also hear from you. Thank you very much. Madam Elizabeth Choge.
Thank you, moderator, for giving me this chance. First, I'd like to thank Mr. Msiga for the elaborate presentation on the digest. Indeed, the digest is very useful. And like the chair of the National Commission on Human Rights said, I think this is going to be useful for most of us practitioners. I really like the fact that almost all the key rulings in this area of citizenship and nationality have been brought out. The Ministry of Foreign Affairs is not directly responsible for issues of citizenship and nationality. But as you've seen in the cases that were highlighted, we are directly impacted by some of them, like the case of Mwende Mwinzi. It's still pending. It's still pending before the court because there was a subsequent application that was filed after she had presented her credentials in Korea. So on a day-to-day basis, we are faced with these cases. There is the ongoing issue of the Miguna case. Much as there are all these rulings, they still, there is now, I think, an application for contempt that is pending before the court. So, I mean, these are issues that that are directly impacting on us, and I'm really grateful for these digests. And I think I like also what has been highlighted, the importance of building partnership with these government agencies, perhaps when you get to interact with them, you'll realize the difficulty they also face in obeying some of these court orders. So I think it's a good partnership going forward. Otherwise, I really don't have much to add. And just to thank Teddy for this digest. Thank you.
Thank you very much, Madam Elizabeth. Yes, quite important, and thank you for giving us the updates on those two cases. I'm sure we will be following them up keenly, just to understand what is evolving in terms of that particular space. Mr. Shumeri, behind you, Ogada.
And I don't think I'm going to respond directly to some of the questions. I'm not in a position to. But I would like to point out a few things that perhaps will put into perspective some of the issues that have been raised here. First, we'd like to thank the conveners of this function for inviting us. We're happy to be part of this. Number two, we would like to thank those entities that have taken time and used their resources to try and come to the aid of citizens of this country who have a few challenges in assessing our facilities or our services. So we would like to thank you, because any help to our citizens is welcome from any quarter. So as a practitioner, some of the things that have come out here I would like to say are interesting. Normally, we are faced with a chicken and egg situation when it comes to registration. What comes first, documents or just declaration? If somebody walks up to you and says, I'm a Kenyan citizen, do you need to take their word for it? What happens for the person sitting behind a desk as an officer? So it looks very easy to say, I'm a Kenyan citizen, but then how do we know that? So these are the situations that we need to be put into consideration when thinking of the actions that an officer might be required to take or does not take when dealing with these matters. Sorry. Then we have a few things that are also confusing. I heard that one of the things that is covered in the document is the issue of conflicting decisions made by courts. What happens to an officer when there are two conflicting decisions and you are faced with one situation? What happens? Which one do you go by? So perhaps that's one thing that needs to be brought out by the lawyers or whoever, so that it can give enough guidance to officers so that we don't blame people who are in between a hard place and a rock, because you don't know which decision do you go by, because there are two decisions that have been made by courts on a way forward. Then we have issues of false declarations. When people come to office and make false declarations, and later on go to court to recant what they had said, what are you supposed to do? Are you supposed to take that person to court first to be charged for making a false declaration to you as an officer, and coming back to you to say, oh, now, because it's convenient for me to say that this person was not my husband, what do you do? Because these are the situations that face your average civil servant who deals with registration. And then another thing that perhaps should be captured by the Kenyan law reform is the issue of change of identification. We have people who go to court, they change all their names, and they want to change their passport, they want to change their ID, and they want to change their birth certificate. What becomes of that person? As a person in this country, what do you say that person is? Is he still, if he's a new person, does he still have citizenship? Is he still, do you change all his documents? What happened to the history of the identity of this person? So these are things that perhaps need to be included and considered so that they come out and guide officers. And I would like to say that as a department, we've taken into consideration the challenges that citizens face. And as we speak, we've partnered with all organizations, including those ones that are human rights based, to try and face some of these challenges. We have UN bodies that have come to partner with us. And as it's been pointed out, I think Namati at some point was partnering with our offices in Kwale. So we've taken cognizance of the fact that there are challenges, and we've gone ahead to embrace anybody who is willing to come out and help so that we sort them out. We've also done, or rather, come up with a few strategies to try and make registration, for example, registration of births, accessible. We've realized that a lot of births that are not registered are the ones that happen at home. So we are trying to come up with a strategy where children who are born at home can also access registration at the MCH point when they go for immunization. So that, because we realize that immunization is so high, because it's a matter of life and death. So we've partnered with MCH points so that children can get, when they go for immunization, they can get registered. Lastly, I would like to say as a department, all the decisions made by court that have required us to take action, we've complied with them. I'm not aware of any that we've refused to comply with. I think I would like to stop there. Thank you.
Thank you. Thank you very much, Mr. Shaw Mary, for giving us those important insights. The issue of partnership has come out. And yes, the recognition that indeed there are challenges. Perhaps maybe just one question to you on the issues that were raised by Abdullahi, I believe, on the, multiple or seemingly discriminatory processes where then those that are seemingly not citizens are supposed to give in or hand in more documents than are required. What are you doing about that? Is that an issue that is part of the challenges that you've mentioned, or perhaps maybe there's a reason why that has to be done? As you have mentioned, sometimes, the egg and chicken situation is an issue that you have to handle within your offices. But, being that as it may, it's still, a challenge out here. Perhaps that awareness raising that that you do accept those challenges, and perhaps maybe there are areas or there's a need for that to happen would be something that I would be willing to listen. Maybe, yes. Where is the mic?
Yeah.
Sorry. And any other that, yes, may have come up in the plenary, feel free to raise them.
Thank you. I'm grateful you reminded me of something that I wanted to point out. The issue of advocacy. And this is one area in which we are partnering with other organizations and other entities. The area of advocacy is very important. I think it was Kenya National Human Rights Commission that had brought out the need for people to know the requirements. And for us, we just want to ask people to tell whoever needs to hear this, and I think it's everybody, to register at the right time immediately after birth. Because this saves people a lot of need to come with documents later. And in my experience, the need to give false declaration, and I hope this is not what I want to come out as if all registration is about false declaration, comes later on in life. You don't plan to cheat before you give birth. So when people convenience at a later date is what brings about this false declaration. So if people register at birth, then the need for many documents to come and prove your case reduces. Then the need to come and bring documents that are probably not genuine also reduces. So we would like to point that out as an area of advocacy, that people need to point out that you need to register at birth. The same with a death, you need to register it as it occurs. On the issue of the Mahmoud case, I don't think I can comment on that, because as far as we are concerned, every birth must be registered, irrespective of whether you are a Kenyan citizen or not, as long as it occurs within the country. So I wouldn't think of a situation in the terms of registration of births where, unless it's a late registration, where you need now to prove your case. And that's why I'm saying, please register at birth. You reduce the need to prove your case. I don't know what else you had wanted me to address. I think those are the only areas, and thank you very much.
Okay, thank you. I know we are completely out of time, but there's I'm reminded, yes, we have 2 contributors on this side. We'll give them an opportunity to very briefly give up their comments as we conclude. Thank you.
Okay, thank you very much. My name is Evans Muchege from UNGCR. I would thank the organizers for this event, that is Kenya Law and Namati, for coming up with a very innovative approach to addressing citizenship and nationality issues. We, as UNGCR, state residents or maybe stateless persons are one of our concerns. So we're trying to come up with a regional forum whereby we can address the issues of nationality and citizenship. So my request is whether there would be any interest, maybe from scholars, legal researchers, legal NGOs, and other legal practitioners, to be part of a regional network on statelessness and nationality for all. That will be encouraged by UNHCR in the light of its mandates on the eradication of statelessness and other active organizations. So this is being organized, and very soon we are going to launch it so that we can bring together our minds and promote capacity building and research on the right of population affected by statelessness. So basically, those who have interest, maybe I can have your contacts. We are going to contact you in the next few weeks. Thank you very much.
Thank you very much, Mr. Evans from UNHCR. We recognize the work that you do, and obviously there's a call for partnership. The last, yes, question.
Okay, thank you very much. My name is Paul Abuto. I'm from the National Registration Bureau. We register and issue ID cards. I thank the organizers of this forum for bringing such a good forum where we can exchange ideas. In our presentations, there was the Mr. Mohammed Abdullahi, the Nubian Kenyan whose mother is a Tanzanian. I want to believe that whatever he said, he just didn't say it for it to be heard, but he said it so that some action can be taken. It sounds like a very challenging situation where the mother went with him to Tanzania when he was young, and he came back when he was an adult. So when he comes in as an adult from Tanzania, the officers have the challenge of ascertaining the paternity. We know the mother is Tanzanian, he has told us. Now he's telling us the father is a Kenyan. Fine. Who is your father? This is my father. Okay. One way in which we check or we prove that you are who you are is through your fingerprints. That's why your fingerprints are taken when you're registering for an ID card, because that is the only sure way that can distinguish persons. Even twins don't share fingerprints. Now, if he has brought his father, and the father has an ID card, but his fingerprints cannot show, it gives us the challenge of now, okay, how do we now then know? What I want to say is, for the sake of his case, and not only as an individual, but so that it acts as a reference, I would like to invite him so that we have closer talk with him, so that even if we can call for his father to come, so that we check indeed if the fingerprints are showing or not, so that we can see how to handle the matter, because the result will be replicated to others who have similar problems. Thank you.
Thank you very much, Mr. Guto. The highlight of the plenary session, and I think it has been very, very, very fruitful thus far. And yes, that invitation, we appreciate it, and I'm sure Namati and my partners will take that forward. And therefore, we are concluding this session and getting into the gist of the forum, which was the launch of the Citizenship and Nationality Rights, a book that we hope will speak a lot to all of us, in whichever shoes we are wearing, whether we are government, whether we are the academia, whether we are communities, whether we are media, whether we are in all walks of life, and inspire what has come out in our little spaces to create and make a difference. I'd like to invite Professor Mwimali, who will invite our chief guest, Professor Winfred Kamau, to share with us her thoughts, even as she represents our chair, before we launch the book. Karibu sana, Professor.
Thank you very much, Janet, for a very good and illuminating session. It has not just been an interaction for the purposes of launch. I think there are people who will leave this place, especially with the last comment from one of our guests, who will be helped. I think some of the issues we raise are not just academic in nature, but they are those that touches upon our individual mandates on the one hand, but also help to bring some solution to members of the public whom, for us in the government sector, are intended to help. So we are hoping that we'll continue with this very illuminating engagement. And I think it's not the end that we launch this book today. We are going to start immediately to engage with the learning institution, the universities, where we'll have discussions around these areas. We have gotten very good feedback about what can be done beyond what we have already done, including now synthesizing the cases that we have reported and ensuring that it percolates and has a greater impact. We are so grateful to our partners, Namati. We do not take it for granted that they took the opportunity to partner with us on this very noble engagement, and I believe that it's only a beginning. We are going to do greater things with them. I want to take this opportunity to invite the representative of our chair of council, who is the Honorable, the Chief Justice. She was unfortunately otherwise engaged and could not join us today, but she sent a representative who would make a few remarks of her own and also give read the speech from the chair. I invite Professor Winnie Kamau, a long-term colleague of mine and also a board member at the National Council for Kenya Law, National Council for Law Reporting, Kenya Law. Thank you and welcome, Professor Kamau.
Thank you. Good morning, everyone. It's a delight to be here among you during this very important occasion of the launch of the Citizenship and Nationality Case Digest. I come actually now in three capacities. One, as a representative of the academia, as Dean of the Faculty of Law of the University of Nairobi, and I'm glad to see colleagues also from other universities. And this interaction has been exceedingly important and significant, particularly because of the opportunities that it offers for partnership between Namati, between Kenya Law, civil society organizations, government, the academy, and other stakeholders. So I'm particularly happy that I sense that there is a wind of change in terms of the way things are approached and the opportunity for dialogue and partnership. I also come in my capacity as a board member of Kenya Law. And thirdly, and more specifically, at this time, I am honored to read the speech by Honorable Martha Koome, the Chief Justice of the Republic and Chairperson of Kenya Law. So I will read the speech. Honorable Council members, Kenya Law, Editor, CEO, and staff, Kenya Law, members of the board and management team of Namati, government representatives, representatives of academia, development partners, civil society organizations, media fraternity, ladies and gentlemen. I thank you all for joining us today as we launch the Citizenship and Nationality Rights Case Digest, a useful resource tool for community awareness and collective action that advances citizenship and nationality rights in Kenya. Citizenship provides the direct relationship between a person and the state. The basic principle is that it accords formal equality of all citizens as individuals within the state. Nationality and citizenship entail development of internal cohesion and external stability of the state. Therein lies not only loyalty, but also the regeneration and survival of the state through time. Ladies and gentlemen, to appreciate the gravamen of issues sought by parties seeking to secure the rights of nationality and citizenship, our history must never be forgotten. The repealed constitution adopted a restricted approach towards citizenship, placing minority groups, trans-border communities, and women at a disadvantage. Kenyan citizenship was primarily based on descent from a parent with Kenyan citizenship, with legislative restrictions targeting women, children, and minority communities, especially trans-border communities. Kenyan women were unable to pass citizenship to their children born outside Kenya and to their foreign husbands. Children were not automatically guaranteed citizenship under the repealed constitution, despite provisions of the Children Act. This exposed thousands of individuals to statelessness and consequently denied them access to basic amenities and inherent rights. Kenya was and still is a signatory to several international law instruments like the International Covenant on Civil and Political Rights, the Convention on the Elimination of All Forms of Discrimination Against Women, which we call CEDAW, and the Convention on the Rights of the Child. As a party to these treaties, Kenya has the obligation to guarantee that no person is deprived their nationality and citizenship arbitrarily. However, that was not the case. The nationality law then neither contained measures to protect one from statelessness, nor provided reprieve through judicial or administrative review of decisions of administrative bodies relating to nationality and citizenship. Systemic practices influenced by years of insufficient legal protection had a greater impact on vulnerable and marginalized communities. Ladies and gentlemen, Chapter 3 of the Constitution of Kenya on citizenship is a result of a people-centered and people-inspired process. It not only expresses the people's aspirations, but also seals their ambitions as constructs that should be implemented indiscriminately. The Constitution guarantees rights, privileges, and benefits of citizenship and sets out the processes of acquisition and retention of citizenship within the confines of the law. These include documentation and renunciation of citizenship. Without belaboring the robust foundation of citizenship that the Constitution has set, it is only right and prudent to recognize this milestone inspired by the Constitution and resultant laws like the Kenya Citizenship Act of 2011. These have been highlighted in the publication of the digest being launched today. Ladies and gentlemen, the digest consists of a wide array of case law delivered by the superior courts of record on various themes across Kenya. It offers a glimpse into the different perspectives the courts have determined on nationality and citizenship, including the call to the respective stakeholders to take fair administrative action when faced with matters concerning the determination of citizenship and nationality of individuals. In addition, a careful selection of comparative analysis of foreign jurisprudence and case law on nationality and citizenship has been included in the digest. That speaks to the importance of protecting the fundamental rights of all citizens within state borders. This robust collection of case law affirms the rights of citizens, highlighting cases that set down proper processes on acquisition and renunciation of citizenship, and most importantly, highlights the need to safeguard fair administrative action in all respects. The digest is people-friendly, easy-read text containing brief and precise summary of case laws. A publication authored for the benefit of not only the legal fraternity, but also the citizenry at large. As the chairperson of Kenya Law, this is the Chief Justice speaking, I am proud that the launch and dissemination of this digest contributes to our key mandate and motto, which is where legal information is public knowledge. Indeed, it would be a disservice to the nation if these case laws were to remain in files and shelves gathering dust, never to be read and tracked by those who require our services and dedication. It would also be a disservice to the constitution-making process and to the legislative progress if the case laws on citizenship and nationality remained scattered and nearly untraceable in databases hosting thousands of case law. The publication of these digests is therefore crucial to the judiciary's vision as an independent institution of excellence in the delivery of justice to all. In conclusion, I acknowledge the effort and commendable work that has gone into the accomplishment of this work. Kenya Law management and staff have been instrumental in the sourcing and compilation of the relevant case law. Their commitment to the process has been crucial in the development of this case digest. I also appreciate Namati's management, participation, and contribution, which is admirable and a true reflection of the extent to which partnerships can deliver a well-executed task. The guidance and commitment of Namati in the development of this digest is laudable. It speaks to the future of collaborative vision to achieve universal access to justice for all. To all our stakeholders, I appreciate the enormous contribution toward the publication of this digest. To the judges, because of your participation in the development of jurisprudence in this thematic area, the resultant publication of this digest would not have been possible. I believe there are areas that we have been called to consider more pertinently in service delivery as we continue to dispense the administration of justice. Let us pull together in furtherance of this honor bestowed upon us by the Constitution, regional, and international obligations. I thank all the participants present here today, in person and virtually, and I believe that the unveiling of this digest will go a long way in advancing the rights of the citizenry on citizenship and nationality rights. I am therefore pleased to launch the Citizenship and Nationality Rights Case Digest. Thank you, and God bless you all. From the Honorable Justice Martha K. Koome, EGH, Chief Justice and President of the Supreme Court of Kenya, and Chairperson, National Council for Law Reporting. Thank you very much.
Makofi kwa Professor. You know, they say a problem well stated is half solved, and today we presented the problem, and we attempted at a solution in coming up with the Citizenship and Nationality Rights Digest. And another solution has been presented by the panel discussions that we've had. We've had the challenges that everyone faces, and we've had a nice discussion, and hopefully it will lead to more fruitful deliberations and better actions towards addressing these issues. Now is the moment we've all been waiting for. I still ask you to be patient. We're just launching the book, and we'll soon be closing. So at this juncture, I'd like to bring up the following persons to help us launch the book. To help us launch the book, professors, please. Professor Winfred Kamau, Dean of the University of Nairobi School of Law, on behalf of the Chief Justice. Professor Jack Mimali, CEO and editor of the National Council for Law Reporting. Ms. Laura Goodwin, Program Director, Citizenship, Namati. Dan Munyoki, the DCEO. And representative from the Kenya National Commission of Human Rights, if there is any. Kenya National Commission of Human Rights. So at this point, I'll just move this podium, and all our attentions will be directed towards this book right here, this dummy, and we shall be launching the publication. So you have the floor. And Mr. Evans and Mr. Shumeri, you might also join us, representing the various government agencies for the ribbon cutting. Before we commence with the ribbon cutting, we have So ladies and gentlemen, the official launch of the Citizenship and Nationality Rights Case Digest. Coming round, we'll have some ushers giving you a gift basket containing the digest itself and a couple of other publications from Kenya Law. Makofi tafadhali, makofi, makofi, makofi. It's been a long process to come to this point, so makofi for the official launch of the Citizenship and Nationality Case Digest. So ladies and gentlemen, the ushers are coming round. You'll receive the gift basket containing the Citizenship and Nationality. There's still a lot of food you can have. We're coming out to the close of the session. We'll have a few things happening, just a vote of thanks and a small photo shoot. So as of now, please, makofi for the launch, makofi, makofi. It's a beautiful picture. Makofi, makofi kwa watu kwa makofi. So thank you very much. At this point, we'll have the closing part of the ceremony. But please feel free, the food is still available. If you want to have a few bitings before you leave, please feel free to leave. We'll have a vote of thanks followed by a closing prayer. So right now I call upon Teddy Musiga to give us the vote of thanks. And I'll give you the instructions regarding the photo shoot very soon.
Thank you so much, Mr. Ribia. On behalf of the staff of Kenya Law, are we there? All right. On behalf of the staff of Kenya Law, I'm here to give us the vote of thanks. First of all, I want to thank our chief guest, Professor Winfred Kamau, representing the Chief Justice. Thank you so much for honoring us today. Thank you to Namati, our partners, who sponsored this book, and for the collaboration we've had together. We pray that we'll have more of these, probably volume 2, dealing with the other issues that we didn't cover in this book. Thank you so much to our council members who are present. There's one, Professor Kamau again, and other council members. Distinguished guests who are present, the government agencies that are represented here, Dr. Mogesa, thank you so much, Human Rights Commission, State Law Office, Madam Elizabeth Choge, we had the Registration Bureau, Mr. Buto, and many other government agencies that have been represented today. We thank you so much for your time and for coming to grace our occasion. Thank you to our developmental partners, the ones we've been collaborating with. Many of you are here, some of you left early. We thank you so much for being with us. Members of the civil society, Amnesty International was here, the Kenya Human Rights Commission is represented, the UNHCR is here, KCLF is here, and many other organizations that I have not mentioned. We thank you so much for being here. For members of the academia, the Dean Riara was here earlier. I can't see, I think she's left. We've seen Kisii University represented, University of Nairobi is represented, Kenyatta University is represented, and any other university that I may not have seen, feel very much welcome. Catholic is here. We also want to thank everybody else who is here. If I may have missed you in any of the categories, please feel appreciated. It is not a small feat to leave your office on a Friday morning when you have very many other things to do to join us here. We want to thank you, each one of you personally, to the hotel and everybody else, the service team, the people who've been in charge of the technical crew, streaming the event live to our online participants. We want to thank all of you. And everybody else, if I may not have mentioned you, please just feel appreciated, all right? Thank you so much for coming. I think we've come to the end of our program. God bless you all.
Ladies and gentlemen, we've come to the end of our program. As you leave, there is a lady called Pauline at the registration desk. So kindly as you leave, sign out. We have a small token for each and every participant who came today. So just make sure you pick up your token as you leave. So thank you very much. If you have any questions regarding Kenya law, prayer. Sorry, I forgot about that. So we'll have a closing prayer. My apologies. It will be done by Mr. Jamal Hamza. Closing prayer by Jamal Hamza.
Thank you. Good morning. Let's pray. Bismillahi wa salatu wa salamu ala Rasulillah. In the names of Allah, the most gracious, the most merciful, honor of the day of judgment. You alone we worship Allah, and you alone we ask for help. Guide us to the straight path, the path of those whom you've bestowed your favors upon, not of those whom you venged your anger upon, nor of those whom have gone astray. Ameen. Wa sallallahu wa sallam ala Sayyidina Muhammad wa ala alihi wa sallam. Walhamdulillah Rabbil Alamin.
Social media at My Kenya Law on all social media platforms. Thank you very much. My name is John Rabi. I've been your MC for the evening, and have a good afternoon.